we're moving forward with litigation against EOIR of Newark. We filed a complaint last Friday alleging that many different things are going on in the Immigration Court of Newark that are impeding our abilities as lawyers to do our jobs effectively. The best way to explain what it is that we're seeing is the reopening or the rushed reopening without adequate safeguards and protocols has put immigration attorneys in New Jersey in a very difficult dilemma. It's this Hobson's choice of litigating your client's rights and protecting their relief at all costs, which means in-person hearings, testimony, and all that work, or choosing between your family's health, your health, and your loved one's health. And that is an impossible way to try to practice law. Our issue really stems from the fact that the statute and the regulation allow for in-person or televideo conferencing hearings. And every other court in New Jersey, from municipal court, state courts, appellate courts, federal district courts, all allow for televideo hearings. This is the way the courts are universally doing or handling hearings since about April in New Jersey. And with some complications, it's moving along pretty well. I mean, the New Jersey State Court is holding trials this way, custody hearings, criminal trials, that type of stuff. And we are asking for, at a minimum, what a municipal court gets, which is a televideo hearing and the ability to see the judge, see your adversary, and talk to them about your client's case. The reason we felt we had to file suit was because in June, the end of June, I want to say June 29th, the chief immigration judge in Newark the assistant chief immigration judge in Newark, I should say, issued a standing order of how they wanted to conduct the hearings that were going to begin happening starting July 13th. And the hearings that were to begin on July 13th were the non-detained merits hearings or individual hearings. The detained calendar is different, and it's been ongoing since April. Now, one of the things that we were asked to do was appear by telephone, but in order to do so, our clients had to sign a waiver of their rights, one of which is waiving the right to object to evidence against them. And we didn't feel that that was smart on behalf of attorneys seeking to protect their clients' ability to stay in the United States of America. Now, another thing we were asked to do was, if you didn't want to appear by telephone, you could come in person. And if the judge, for any reason, had any difficulties reaching you by phone, they could order you to come appear in person. And that seemed punitive to a point. Because if I am an older practitioner, not a 20-year-old practitioner with no health issues, you're asking me to take my life into my hands to go defend my clients. And the pandemic is new worldwide. It's particularly new in America. And in New Jersey, we are lucky we have the technology to be able to handle a case conference or a hearing or a trial with video technology without risking the health of those appearing. And so we weren't given that option. The moral obligation I think EOIR has to its own community where it houses an immigration court is if not as significant, possibly greater. That's their own employees. That's their own staffers. Those are long-time 20, 30-year employees that you're asking to come into this environment. And because they're there daily, let's say if I have one hearing in the week, I have a risk of infection. But if someone's there 5 days a week, their risk of infection is significantly greater than mine. And you're asking them to come in and appear and handle court hearings that could be done via televideo. What comes next is yet to be seen. We have to see how the U.S. Attorney responds and how we can push forward with seeking an injunction, so at least we can obtain televideo hearings as provided by the statute and the regulations. As far as what our AILA membership can do, I've already seen a ton of support from local chapters, from attorneys in the bar, from attorneys outside our bar who've heard of this complaint and are surprised and baffled by what they hear EOIR is doing. And at the same time, we can look at what AILA National's provided with the advocacy toolkit and really harp on those bullet points and those opportunities to work on postponing a hearing under COVID-19. I would personally ask that anyone who is concerned about this litigation reach out to me. I'm happy to talk about it. And if you can, promote our cause on any social media platform that you choose. And that's all.